Hey, greetings everybody. Today on Legalese, you will be joining me for the thrilling conclusion to my two-part series on the Texas border crisis and what everyone gets wrong about the Texas border case, Department of Homeland Services versus Texas. Hey, greetings everybody, and welcome back once again to Legalese. As always, I am your host, Bob, and I want to thank you all so much for joining me here today. And if you happen to be new to my channel, let me bid a special welcome to you. This is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, real quick, I just want to remind you guys, if you would like to learn more about our show, you can go check out our homepage over at legalespodcast.com. And if you want to make sure that you always get updates whenever I put out any new content, and I don't just put out content here on YouTube, I also do a audio-only version of the podcast that is available on Spotify. I also post to alternative platforms like Rumble and Odyssey, but then also I write a lot of articles as well that you can get over at Substack by signing up for my newsletter. If you go to legaleshow.com, you subscribe to the newsletter, you will get notifications whenever I put out any new content, no matter where or what it is. All right, well, let's jump right in today. So today, we are going to be concluding our discussion surrounding the pending case DHS versus Texas. Now, yesterday, we discussed a claim that has recently come to be accepted as the gospel truth for mainstream Republicans, both on the state level in Texas and increasingly on the federal level, with Republican politicians jumping on the bandwagon to get in on some of this good, clean, old-fashioned homemade fun that is lying to yourself, your colleagues, and your constituents about whatever constitutional clause you can twist to fit your melodramatic narrative about immigration. Now, I am of course referring to the idea that the recent increase in the number of migrants illegally crossing the border constitutes an invasion. Now, this narrative is one that Governor Greg Abbott has been most responsible for popularizing, and it is embodied in the following selection from a letter that Abbott released on January 24th. He says, Article 4, Section 4 promises that the federal government shall protect each state against invasion, and Article 1, Section 10, Clause 3, which acknowledges the state's sovereign interest in protecting their borders. The failure of the Biden administration to fulfill the duties imposed by Article 4, Section 4 has triggered Article 1, Section 10, Clause 3, which reserves to this state the right of self-defense. Now, if you haven't seen that video, I would suggest going back and watching it first, but to just give you very quickly the 30,000-foot view, is that in that video, I took the time to demonstrate that the governor's claims about an increase in the number of migrants crossing the border constituting an invasion in accordance with the Guarantees Clause and the Compact Clause is just a plain old goddamn lie.
Why the fuck you lying? Why you always lying? Oh my god. Stop fucking lying. Always lying.
And I would demonstrate that neither the text of the Constitution, the original understanding of that text according to the framers and ratifiers who gave that document legal force, or any reasonable reading by a constitutional scholar or jurist could possibly sustain that interpretation, much less the extraordinary powers the government claims a reasonable construction of those clauses would grant him. Now, that's not even to say that I am either for or against what Greg Abbott is doing to stem immigration. All I'm saying is that that justification that he is using is constitutionally bunk. That's it. Now, it is, of course, that claim we just talked about that he has been using, but we need to keep in mind here, of course, that the Republican Party have by no means have a monopoly on twisting the Constitution or twisting case law to suit their own policy preferences. And as I promised in my last video, today we are going to be flipping the script, and I want to discuss a ridiculous lie about the case that has come from the Democrats thanks to their own dishonest misinterpretation of the actual events that have transpired and a melodramatic and politically biased false narrative that they have been pushing about this case. Before that, though, I think it would be proper to examine the facts of the case and the procedural history of DHS versus Texas as it has played out both on the border and in the lower courts. So, this comes from the Fifth Circuit's decision, which was filed on December 19th of 2023. They talk about how along the 1,200-mile border of the Rio Grande, forming the border between Texas and Mexico, there are 29 official points of entry into the United States. To guard the vast stretches of land between those points, Congress created the Border Patrol, whose objective is to deter illegal entry into the United States. In recent years, illegal crossings have increased dramatically, and the number of Border Patrol encounters with migrants illegally entering the country has swelled from a comparatively paltry 458,000 in 2020 to 1.7 million in 2021 to 2.4 million in 2022. Now, in 2021, Texas would launch Operation Lone Star to aid Border Patrol through allocation of state resources. The activity in question here is Texas's laying of concertina wire along several sections of the riverfront. Now, these sea wire services are a deterrent, and an effective one at that, causing illegal crossings to drop precipitously. And by all accounts, Border Patrol, according to their own words, have been grateful for the assistance of Texas law enforcement, and the evidence shows the parties have worked cooperatively across the state, including in El Paso and in the Rio Grande Valley. Now, Border Patrol has set up a temporary processing center in Maverick County on private land close to the Rio Grande. By September of 2023, Texas had installed over 29 miles of sea wire in this area. Now, both the Border Patrol and Texas agreed that the sea wire must be cut in the event of an emergency, such as the threat of a migrant drowning or suffering heat exhaustion. Now, the problem arises when Border Patrol agents cut the wire without prior notification to Texas for reasons other than emergencies. And so Texas sought a preliminary injunction in the United States District Court for the Western District of Texas based on its trespass to chattels claim. And 3 days later, Texas sought a temporary restraining order. Now, the following day, Texas filed a notice with the district court alleging that, quote, the defendants, knowing a motion for a temporary restraining order had already been filed, used a forklift to seize concertina wire and smash it to the ground, end quote. The court would grant an emergency TRO on October 30th, 2023, barring defendants, quote, from interfering with Texas's concertina wire except for medical emergencies, end quote. Now, although the court would ultimately deny a preliminary injunction on sovereign immunity grounds, the court made numerous fact findings supporting Texas's trespass to chattels claim. As a general matter, the court rejected the defendant's claims that Border Patrol was justified in cutting the sea wire first to inspect, apprehend, and detain illegal aliens, and second, to prevent or address medical emergencies. To the contrary, the court found that the Border Patrol cut the sea wire, quote, for no apparent purpose other than to allow migrants easier entrance further inland. Now, the court would go on to note that it was aware of at least 14 incidents of wire cutting. The court, however, would focus on a September 30th incident because it had been captured on video and was, in the court's view, the most illustrative example. Now, in that incident, a Border Patrol agent cut 2 additional holes in the sea wire 15 feet away from an existing hole and installed a climbing rope for migrants. Meanwhile, a Border Patrol boat was passively observing a stream of migrants crossing the river who were never interviewed, questioned as to citizenship, or in any way hindered in their progress into the United States. Instead, after letting the migrants through, the Border Patrol sent them to, quote, walk as much as a mile or more, and, quote, with no supervision in the hopes that they would proceed to the nearest immigration processing center. Now, the court first rejected as a factual matter the defendants' claim that the Border Patrol's actions were intended to inspect, apprehend, and process incoming aliens. The court found that no alien was actually inspected at all. Moreover, if agents intended to inspect, they could have done so without doing anything to the wire. As the court noted, Border Patrol agents already possess access to both sides of the fence, to the river and the bank by boat, and to the further inland side of the fence by the road. The court also found that wire cutting was not necessary to apprehend or process aliens. Indeed, they would go on to point out that no one was actually apprehended or placed in custody. As the court found, aliens coming through the holes were merely waved along in the, quote, hope that they will flow in an orderly manner to the nearest processing center, end quote. Moreover, agents let some 4,555 migrants in during that single September 20th incident, but only 2,680 presented themselves for processing. Accordingly, the court found that no reasonable interpretation of the definition of apprehension or detention can square with the Border Patrol's conduct. Now, the court also rejected the defendant's argument that the wire cutting was generally necessary to prevent medical emergencies, and furthermore, they rejected the notion that medical emergencies could justify any and all destruction of the sea wire. They said, quote, while an ongoing medical emergency can justify opening the fence, the end of that exigency ends the justification. So, for example, cutting the wire to address a single individual's display of distress does not justify leaving the fence open for a crowd of dozens or hundreds of others to pass through, end quote. And despite making numerous fact findings supporting Texas's claims, the district court ruled that the United States sovereign immunity had not been waived under 5 U.S.C. Section 702, and that the court was therefore barred from converting the TRO into a preliminary injunction according to an order filed November 29th of 2023. And on November 30th, the next day, Texas would appeal to the Fifth Circuit seeking an emergency injunction or a temporary administrative stay pending appeal to prevent the United States Border Patrol from cutting, destroying, or otherwise interfering with concertina wire while the panel considered its motion. The panel granted an administrative stay, prompting the defendants to file an opposition to Texas's request. And on December 19th, the Fifth Circuit would file a published order. In it, they would conclude that the district court had legally erred with respect to sovereign immunity, and that Texas had otherwise satisfied the factors under Enkin versus Holder, and the court would go on to grant Texas's request for an injunction pending appeal, and accordingly, The defendants are, and these are the words of the court, the defendants are enjoined during the pendency of this appeal from damaging, destroying, or otherwise interfering with Texas's C-wire fence in the vicinity of Eagle Pass, Texas, as indicated in Texas's complaint. As the parties have agreed, defendants are permitted to cut or move the C-wire if necessary to address any medical emergency as specified in the temporary restraining order. Now, to give you the TLDR, plain English, no legalese. Legalese, the concept, not legalese, the show. A no legalese summary of the key points of the case background, immediately relevant in the matter that is coming before the Supreme Court. So, first, Texas is suing the federal government in tort for the destruction of state property, being the C-wire barriers and the like. The district court generally concluded that Texas was right on the facts but wrong on the law because Texas could not seek money damages from the federal government due to sovereign immunity. And the U.S. Court of Appeals for the Fifth Circuit would enjoin the federal government from taking additional actions that remove or destroy C-wire barriers on state and private land, save where such actions were necessary to address a medical emergency pending additional proceedings. And on January 2nd of 2024, the federal government would file an application to vacate the Fifth Circuit's injunction pending appeal. This was submitted to Justice Alito, who handles the emergency appeals and applications from the Fifth Circuit when they are seeking review as part of the court's shadow docket. Now, at issue, the Department of Homeland Security was seeking to block the order by the Fifth Circuit that generally bars Federal Border Patrol agents from cutting or moving razor wire installed by Texas along a portion of the U.S.-Mexico border. And the United States Solicitor General, Elizabeth Prelogar, told the court that the order by the U.S. Court of Appeals for the Fifth Circuit bars agents from doing their jobs, specifically from cutting or moving the wire to obtain access to the U.S.-Mexico border and reaching migrants who have already entered U.S. territory. She said that the exception the appeals court created for medical emergencies is not enough. Now, this, of course, is in spite of the fact that that is precisely what Border Patrol had agreed to do when they agreed to allow the wire to go up, but I guess that's neither here nor there. Back to the appeal from the Solicitor General. She would go on to insist, because of the time that it takes to cut through the wires and the very real threat of death along this stretch of river, that is why the exemption for medical emergencies alone is not enough. And in response, Texas would tell the justices that there was no need for them to get involved in the dispute because the Court of Appeals had fast-tracked the case, and it is scheduled to hear oral arguments on February 7th. But in any event, Texas dismissed the underlying premise of the Biden administration's argument. The Border Patrol agents are carrying out their responsibilities under federal law when they move or cut the wire is, according to Texas, simply false. And to the contrary, Texas contended that, as the federal district court in this case found, the Border Patrol agents are not actually apprehending or processing migrants who cross through the holes in the wire that the agents create. And on January 22nd of 2024, Justice Alito would refer the Solicitor General's application to the court, and the Supreme Court would grant the Solicitor General's request on this order on Monday afternoon. And what we found was Chief Justice John Roberts and Justice Amy Coney Barrett would join with the court's three liberal justices, Justice Jackson, Justice Kagan, and Justice Sotomayor, in granting this order. So here is where we get to the issue at hand. You will remember from the last episode how Greg Abbott's declarations of defiance picked up quite a bit of momentum with Republicans around the country following an official statement the governor published on January 24th of 2024. And it's no coincidence that he began doubling down on his protection from invasion claims 2 days after the Supreme Court would grant the application to vacate just 2 days earlier on January 22nd. Now, in this instance, his declaration did not just consist of empty words, but he came along with actions to back them up. Namely, the government of Texas immediately began reinstalling the concertina wire along that disputed 29-mile stretch from which the DHS have been removing it. Now, these actions have been met by harsh and often unreasonable criticism from journalists, scholars, and politicians, many making the patently false claim that Texas's actions constitute a willful defiance of a lawful court order. Now, just as I did in my last video, not that it did me any good, but all the same, I want to clarify that, at least for today, for this video, I am not taking any position for or against Texas's decision to continue installing C-Wire as a matter of policy. However, don't let that stop you from dismissing my criticisms of their political bias on the Democrat side as evidence that I must be some kind of racist, far-right neo-Confederate, and probably an insurrectionist too. I can tell you that my criticism of the Republican political bias was certainly more than enough for people to dismiss me as an America-hating libtard on a mission to destroy our country, as an obvious paid Democratic shill for open borders. All the same, I guess it's worth at least pointing out that in this video, all I am interested in addressing is whether or not Texas's decision to begin reinstalling this wire constitutes an open defiance of a lawful Supreme Court order. And the answer to that question is an unequivocal fuck no. And the reason for this is simple and obvious. Now, let's take a look at the court's entire 2-sentence long decision that they released. So, they said the application to vacate injunction presented to Justice Alito and by him referred to the court is granted. The December 19, 2023 order of the United States Court of Appeals for the Fifth Circuit in case number 23-50869 is vacated. Now, let's quickly revisit the legally binding text of the injunction being vacated. So this is the legally binding finding of the Fifth Circuit, concluding that the district court legally erred with respect to sovereign immunity and that Texas has otherwise satisfied the factors under Enken v. Holder. We grant Texas's request for an injunction pending appeal, and accordingly, defendants are enjoined during the pendency of this appeal from damaging, destroying, or otherwise interfering with Texas's C-wire fence in the vicinity of Eagle Pass, Texas, as indicated in Texas's complaint filed October 30th, 2023. And so, just to give this in very plain, simple English, what this order says is the Department of Homeland Security are prohibited from damaging, destroying, or otherwise interfering with Texas's C-wire fence in the vicinity of Eagle Pass, Texas, until this appeal is concluded. Now, what you might have noticed is that that order only addresses the actions of Homeland Security. It does not order Texas to do anything. So if the Fifth Circuit's order had nothing to do with Texas installing C-wire, and if the Supreme Court order only vacated that order that has nothing to do with Texas installing concertina wire, then how precisely, I ask, does Texas's continued installation of concertina wire defy the Supreme Court's order? And this is so painfully obvious that even with my incredibly low expectations of people's ability to have a reasonable understanding of the law, anytime they approach it with even a modicum of political bias, I gotta be honest, even I find myself flabbergasted that this is a point that has to be made. It seems unbelievable that people who really should know better, including journalists working for major news networks and distinguished legal scholars, are ready here to cry havoc and let slip the dogs of war.
Cry havoc and let slip the hogs of war.
Dogs of war.
Whatever farm animal of war, Lana, shut up.
Now, a good example of this would be what we have seen coming from Face the Nation, which is a CBS News show that would release the following video and tweet. So the tweet reads, Texas is defying demands after the Supreme Court ruled that the Biden administration can cut razor wire installed by the state to deter border crossings, quote, paving the way for yet another legal clash between Texas and the Biden administration over immigration, end quote.
Camilo, I see what I think is National Guard personnel behind you. There has been this standoff between the state of Texas and the federal government about that park you are nearby, where a lot of migrants touch ground after crossing the river. What's the latest on that showdown?
That's right, Margaret. This public park behind me in Eagle Pass is now at the center of an extraordinary legal showdown between Texas and the Biden administration over the future of U.S. immigration policy here at the border. The Texas National Guard commandeered this park back in early January and has since blocked Border Patrol agents from entering this park. This had been used by Border Patrol to process migrants, but now Texas has fortified it with razor wire, fencing, and other barriers to impede the passage of migrants. Texas says it needs to do this to deter illegal crossings, Margaret, but the Department of Homeland Security is demanding that Texas relent, saying that this is an unconstitutional action. Texas right now is defying those demands, so that is paving the way for yet another legal clash between Texas and the Biden administration over immigration.
And last, but certainly also least, is an article written by Erwin Chemerinsky, who is one of the most prominent and distinguished legal scholars in the United States, and he is considered a national leading expert in constitutional law. And yet he would go on to write an opinion piece, which is both an accurate description of the context of his published article as well as the quality of his writing and scholarship in that article. Now, this piece was called Opinion. Texas Governor Greg Abbott is defying a U.S. Supreme Court order that's frightening. And his opinion piece is, in my opinion, a real piece of, well, I think you know. It's shit. I was going to say his opinion is a real piece of shit.
You got me now. You got me now. You got me now. Oh, you figured me out. You fucking income fucking poop. You figured me out. You got me red-handed. You got me red-handed.
Now, Erwin's article makes a number of ridiculous and just plain wrong claims, including baffling claims that go beyond the relevant issue about whether Texas is even defying a Supreme Court order. So in the article, he says, quote, the dispute arose because Texas installed razor wire fencing along parts of the Rio Grande, among other unilateral measures at the U.S.-Mexico border. Now, what is so absurd about this is that, as we have already discussed, the placing of razor wire was not a unilateral decision by Texas against the federal government's wishes. If we remember in the Fifth Circuit decision we went over just a moment ago, they found, and again, this is a direct quote from their findings, by all accounts, Border Patrol is grateful for the assistance of Texas law enforcement, and the evidence shows that parties have worked cooperatively across the state, including in El Paso and the Rio Grande Valley. So, if federal border agents, by their own admission, were grateful for the assistance and work cooperatively with the branches of Texas law enforcement in installing this C-wire in many locations across the state, including the one in question, I fail to see how the initial placement of razor wire was a unilateral act in defiance of the federal government's Border Patrol agents' wishes. Irwin goes on to claim that Governor Abbott is defying a Supreme Court order and that what he is engaging in and what most fellow Republican governors are cheering on is a frightening act of pure lawlessness. Now, he then relies on the most favorite move in the progressive playbook, claiming that Governor Abbott is simply a racist. Now, as to that point, I would simply respectfully disagree with Irwin that Governor Abbott's actions constitute racism. However, it is his next point that I believe just simply goes way too far. Now, he claims that his actions are no different than those of Orville Faubus, the former Arkansas governor and unapologetic segregationist who is best known for using the state National Guard to prevent black students from attending Little Rock High School. Governor Faubus's actions led to the landmark Supreme Court case Cooper v. Aaron, as well as famously inspiring Charles Mingus to ridicule him in his classic song, Fables of Faubus.
With the Sabbath. Now tell me someone is ridiculous. Governor Orville Faubus. Why is he so sick and ridiculous? 2, 4, 6, 8, name me what is this you hate? Oh, with the Sabbath. No more swastika! Now tell me someone who's ridiculous. Governor Orville Faubus. Why is he so sick and ridiculous? 2, 4, 6, 8, name me what is this you hate?
However, I don't want to give the impression that there are no reasonable voices on the liberal side of this issue. I actually happened to find an excellent article posted by lawyer and legal professor Stephen Vladeck. Now, Vladeck is a professor at the University of Texas School of Law. The guy is notably quite liberal. He appears as a regular legal commentator on CNN. He has been an outspoken critic of Donald Trump and Governor Greg Abbott, and he has been especially critical surrounding their very similar views on border security and immigration policy. But in this instance, he gets it so right. I am just going to let his statement speak for itself. He says perhaps the most important thing to say about the order is how little it actually resolved. By vacating the Fifth Circuit's injunction, the court effectively protected the federal government from contempt sanctions if it continues to remove the razor wire that Texas had placed along the border, and nothing more. Thus, nothing Texas did or said later in the week was defying the court's rulings. Much like President Jefferson and Marbury versus Madison, there was no real way that Abbott could defy such a modest ruling because it wasn't directed at Texas in the first place. Instead, as explained in more detail below in his piece, and his piece will be linked in the show notes page, and I'd actually encourage you all to go read it. Sorry, while it's on my mind, I just want to let you know that on the show notes page for this episode, you can always find links to all of the case briefs and opinions of the courts that I referenced here, as well as any other articles or media sources. Everything I touch on here, you can find on the show notes page. But anyways, I digress here. Getting back to Stephen Vladeck, he said, instead, as explained in more detail below, the real legal dispute between Texas and the federal government at the border remains very much open and unsettled, and are likely only to escalate further, given the politics of the moment. And he, correctly, a little later in that article, goes on to point out that this is a major problem that is inherent in the court's increasing use of the shadow docket. And for anyone who might perhaps want a better understanding of what the shadow docket is, you can find out what the shadow docket is and why it tends to lead to problematic outcomes like this in Vladeck's excellent book, The Shadow Docket, and it is a good read. All right, so as Vladeck would also note later in that same article, there are other pending cases that challenge the lawfulness of actions Texas has taken that do conflict with the Biden administration's immigration policy enforcement choices. One of these cases challenges a new immigration law in Texas that looks highly suspect under the landmark Supreme Court case we discussed at length in my last video, Arizona v. United States. This was a 5-4 decision in 2012 in which the court concluded that many state actions to enforce federal immigration laws are preempted. Now, if you would like a video about the law that he is talking about here, off the top of my head, I think it's Texas SB 8. Don't quote me on that, but if you guys would like a video going over that law and the upcoming challenge, let me know in the comment sections. But back to the matter at hand. If the court rules against Texas in those cases, and I suspect it's very likely they might, and Texas does not stand down at that point, then it will be appropriate to call out the Lone Star State for defying the Supreme Court. But that is not what has happened yet, and it is irresponsible for journalists, politicians, lawyers, and others who should know better to say so. All right, well, that's really all I have for you guys here today. Thank you so much for tuning in and checking out the program. Now, if you would take a moment and do all of those things for me, please, that help to trigger Al Gore's rhythm. If you liked the video, hit the thumbs up button. If you disliked it, hit the thumbs down button. Maybe leave me a comment. Let me know what you liked or disliked about it. Let me know what you think about this topic. Let me know if there's any other areas of this topic you would be interested in learning about. Or if you just want to leave a message telling me how great a job I did and how awesome I am, that is fine. Flattery will get you everywhere with me. And, of course, please make sure to subscribe to the channel so you always get notifications when I send out new videos. And consider, of course, subscribing to our newsletter at legallyshow.com so you will get notifications whenever I post any new content. And so I guess until next time, this has been Bob for Legalese, talking about the Texas border crisis case. And, of course, as always, Carthago delenda est.
Motherfucker, like Freddie Mercury.
got a trunk full of M's, brother.